Nicole, perhaps to get back to you, just listening to Tony Ngeni there, he actually has stressed the point that this should not be a case around imprisonment or one that carries that type of a sanction of imprisonment, but rather a fine. And that's what we were touching on, that we heard arguments around her advanced age and the nature of the offence. But I also heard there, with the state taking exception to that agenda to somewhat trivialize the nature of perjury. Talk to me about what is at the core of this particular offence and given her status in society.
So perjury, the crime of perjury is essentially one of lying to the court and of misleading the court. And one might, given that definition and explanation, think that it's not a particularly serious matter. It doesn't amount to, any deaths or necessarily obvious harm. But I think it's important to contextualize this. This is a minister, a former cabinet minister, who is holding the office at the head of a department responsible for those who were most vulnerable in South Africa. And essentially, she misled the highest court as to her involvement in the social grants crisis, which was one, as I said, which essentially endangered the continuation of distribution of grants to social grant recipients. And I think that is enormously consequential. That she is, as a cabinet member holding executive authority, not only failing to observe her role and her responsibilities, but actively lying to the highest court in the land. So essentially to mislead them and set them off course if she had succeeded, which would be to the detriment not only of social grants recipients, but to the public at large. It would have been a waste of taxpayers' expenses. The Constitutional Court's involvement in that matter has been going on for years. It has been extensive. It has been enormously costly. And an attempt to mislead the court in those circumstances, I think, must be understood to be of the most serious type of harm.
And then what do you make, though, of those who are her supporters who would say you need to try her as an ordinary citizen, particularly a pensioner, as they say, not necessarily say here you are sentencing a former minister, but a citizen of the country, so you do not necessarily need to make a further example, just work within the confines of the legislation, which somehow sort of guides the type of sanction that comes with such an offence?
But she was not an ordinary citizen. When she committed this offence, she was the Minister of Social Development. And she sought to lie to the court, to mislead it as to her responsibility. She would have not only... so essentially it is abuse upon abuse. So not only did she participate in a grant of an unlawful contract and seeking to extend that unlawful contract without any proper oversight and supervision, and a contract which essentially made even more vulnerable social grants recipients. So they were vulnerable to the use of their information by the company which had been given this unlawful contract. But then, on top of that, she then seeks to mislead the court as to who bears responsibility for that. So again, if she had been successful, the court's time and attention wouldn't have allowed a curing or a correction of that abuse. It would simply have been a further distortion and abuse of the court's time and processes. And I think that is the context in which this particular crime must be seen and must be appreciated. She was a cabinet member exercising executive authority. She was a servant of the South African public, and that responsibility is key to understanding the significance and the extent of her offence.
All right, Nicole Fritz, thank you very much for your time.